For the others, 110 or whatever number, 126 minus 36 will be now based on that RFP will be produced through the strategic partnership in India. So, Deputy Speaker, sir, that Make in India approach for the rest of them, other than the 36 which is coming under flyaway, like the 18 that you wanted to get from flyaway, will be manufactured in India, but the process is through a transparent mechanism of strategic partnership. All right? Sir, that is one set. Now, I want to answer the questions or clarification which Honorable Member Rahul Gandhi ji has asked. Now, I just want to highlight, Madam, yes, due to, I spoke for a long time, I thank every member of the House for the indulgence that they've given me, because it meant a lot. I needed to answer on every facts. I could have elaborated a lot more on offsets. I shall do that now because that has been raised as a question. The offset contract, Madam, under the Rafale agreement, are governed by offset guidelines of the Defence Procurement Policy of 2013. That policy is not made by us. That policy was already given to us as a result of the policy we framed in UPA. Now, as per the offset guidelines, the Defence Acquisition Council may prescribe varying offset obligations. It could be 30%, it could be 40%, it could be 50% in special cases. Accordingly, an offset obligation of 50% was prescribed for the Rafale. Not 30. We didn't stop it at that. We said 50%. If we buy for 100 rupees, 50 rupees worth you have to either procure from India or invest in India, and therefore then come and claim the credit. Now I want to tell you, Madam, 2 offset contracts were signed, one with Messrs. Dassault Aviation and another with MBDA on 23rd September 2016. The same day on which the intergovernmental agreement was signed between Government of India and Government of France for the procurement of the 36 Rafale in flyaway condition. Now, I also want to say here that the offset obligation can be fulfilled, and their commercial decisions which these original equipment manufacturers can make, the government does not go and put it as a part of the intergovernmental agreement at all, as to who they should go with, who they should not go. 100 companies, 200 companies, they decide. The government does not. Then they have to give reports to the ministry to say, this is where we've invested, or these are the products we've bought from those companies, and claim offset obligation fulfillment ka credit. Because without that, if they don't claim, we can always levy penalty on them, saying the obligation that you have for investing or buying up to 50% from India, you have not fulfilled, and therefore we lay a penalty. That can be done if they don't come to us. But they have time to come and claim that even now. That is why, in spite of all that is reported in the media, saying they're going with them, they're going with this, don't you know it, don't you know it? Officially, I can state that they're going for offset with so-and-so or so-and-so only when they officially come and claim it from me. Till then, I can't respond on the basis of media report that offset is being fulfilled by this company or that company. That is not something which I can state. So, it is stated here, I want to put this on record, ma'am, that so far as discharging of the offset obligations by OEM and its Tier 1 vendors through Indian offset partners is concerned, there is no mention of any private Indian business house or houses in the IGA or offset contract. The offset contract does not envisage manufacture of 36 Rafale aircraft in India by any public or private sector firm. The 36 is coming flyaway condition from France. As per the offset contract, the vendor or the OEM, the original equipment manufacturer is required to confirm the details of IOPs, the Indian offset partners, or products that they're buying, either at the time of seeking offset credits or 1 year prior to the discharge of the offset obligation. So there is time for them to come and claim with me that this is room which they are going. And therefore, till then, I can't state anything openly based on media reports. The annual offset implementation schedule, as per offset contract, will commence from October 2019. The annual, I repeat because the noise has started again, I repeat it, madam, so that you can hear it. The annual offset implementation schedule, as per offset contract, will commence from October 2019. The vendor or the OEM is yet to submit a formal proposal in the prescribed manner, indicating details of IOPs and products for offset discharge. I would want to underline the share of Dassault Aviation in the total offsets. The share of Dassault Aviation in the total offset is 19.9% only. And there will be many Indian offset partners of Messrs. Dassault Aviation under many avenues. So I want to draw your attention to that now. Therefore, I have already explained about the HAL. Now, just one little additional clarification, because all of us are very, very sensitive about our names being taken up. Even if exact quotes are produced, we are very worried about the names being taken. So am I. I was called. That remark is expunged now, I understand. But I was called duty. I'm sorry, unparliamentary it might be. It was. I heard in the millie on that day, Raksha Mantri Nirmala Sitharaman jhoot bol rahi hai. Later on it was expunged. Later on it was expunged. Now, Raksha Mantri is jhoot bol rahi hai. Pradhan Mantri chor hai. Ye bhi is parliament mein bola gaya. Pradhan Mantri jhoote hai. Ye bhi idhar bola gaya, madam. So, if some people have thin skin and they get very sensitive about their names being taken, even I'm sensitive, madam. I don't have a khandan to boast of. I come from ordinary background. I come from ordinary background. I come from a middle-class family. I come with my honor intact. Pradhan Mantri ji comes from a very low, poor economic background family. He has come up the hard way. His name is untarnished till today. He is not corrupt. And he has led a clean government. You call them chor? You call them jhoote? And you expect us to sit quiet? And today, because I've quoted conversations from his press conference and his statement in the parliament, my name was taken, so I should be given an opportunity. Even I have my honor intact, madam. Prime Minister has his honor intact, madam. We all want to be respected, madam. We don't have nobody. I'm sorry, madam. I'm sorry, madam. I will have to say this. Just because we have Khandan name next to us, it doesn't give any right to anybody to call the Prime Minister chor. It doesn't give any right to anybody actually to call them jhoote. You did that. And when I stood up to defend myself, your entire party drowned me down that day on the vote of confidence day. Your entire party stood up and drowned me. You didn't ask them to keep quiet that day. Today, when you want clarification, you're asking my respected members to say, listen, allow me to speak. Did you allow the Prime Minister or me to speak that day? You shouted me down. You called me duty. You called me asatya. You said all that. I can't defend myself. Madam, another thing, madam, here. It doesn't, it's not the prerogative of only Khandans to protect themselves, madam. We all come from normal backgrounds, fight our way through the system to be where we are. We have our honor intact. It's not anybody's business to throw us like that. I'm sorry. There was no reprieve. There was no attempt by the Congress leadership to stop the members from calling us like that, from throwing paper aeroplanes at us, from sitting and laughing and heckling at us, from hugging the Prime Minister and going winking there. Did anyone stop them? Hug the Prime Minister and then go wink there? Is this not insulting? Is this not insulting my Prime Minister? Is this not insulting? Ah, yes. When it is your leader, it is wasting time. My honor, the Prime Minister's honor, everything has been insulted in this house. Have you all ever apologized? Have you ever apologized? Having winked your eye after having hugged the Prime Minister, having called the Prime Minister a chore, having called the Prime Minister a thief, have you ever said sorry? I'm sorry, madam. This is not the way. It doesn't give anybody the right. Nobody has the right to call others like that. I may come from a very ordinary background. Prime Minister may come from an ordinary background. Who gives them the right to call us like that? Who gives them the right to call us? I'm sorry, madam. This is not the way this parliament, when I come in, like the way Prime Minister did naman on the floor, all of us feel very honored. No, madam, I would want to take this opportunity. All of us feel very honored coming from ordinary backgrounds to be in this wonderful house where eminent people have been here. Eminent people have been here. Even some of their own senior leaders. Jawaharlal Nehru, Pandit, Jawaharlal Nehru, Sardar Patel, all of them. When we come into this house, we feel very touched that we got the honor of being here. And our reputations are available for you to insult us the way you want to insult. Please. And not a word of apology. I'm sorry, madam. This is not the way this house should run. Thank you for this opportunity.
Please, now nothing. No. Now we will take item number 19 and 20. Item number 19 and 20. No, nothing. 3 and this is discussion together. N.K. Premchandran to move statutory. No, nothing now. It's okay. Whatever has happened, very good. Whatever she had said, that is true also. वो पेपर के हवाई जहाज फेंके भी गए. I have seen all these things. Now please don't. It's okay. Premchandran.
Call the next name.
Yes.
Next name. Call the next name.
N.K. Premchandran, resolution you don't want to? You don't want to speak? No, nothing. I'm not going to. Not every now and then.
Next member.
Yes. Professor Saugatra is not here. What is this? Item number not on this. Are you not speaking? N.K. Premchandran, you have to move the resolution. Are you not? I have taken item number 19 and 20. No. We have gone next item. Not now. Nothing.
Call the next member, madam.
Betty.
Call the next member. This one.
Adhir Ranjan Chaudhary also. You also don't
want.
Yes, Saugatra is not there. Shashi Tharoor is also not there.
The minister.
Okay.
Minister.
Now, dear.
Madam Minister. Minister.
Minister.
P.P. Chaudhary.
I'm taking the other. Minister P.P. Chaudhary. Yes. Please, please.
Madam, I rise to move that the bill further to amend the Companies Act 2013 be taken into consideration. Madam, in fact, the government constituted a committee in July 2018 under the chairmanship of the Secretary of the MCA, with a view to review the existing framework of the Companies Act 2013 and make the certain recommendations with respect to the offences and with respect to the related matters. The committee held number of meetings, and for recategorization of the offences, the committee made recategorization of the offences. Those were of the compoundable nature, and those offences were normally, before that, those offences were required to be adjudicated by the special courts as well as by the NCLT. Therefore, those offences were taken out from the special courts as well as from the special courts and from the NCLT. Therefore, the committee gave its recommendation on 27th of August 2018, and with respect to the severity of the offences, certain offences of a serious nature under section 447, those offences were retained as such. The offences which were of compoundable nature, those offences were taken out, and it has been provided to the in-house mechanism, and that mechanism has been to be enhanced and to be provided in the ministry itself. Now, it will serve the twin purpose. One is because the certain lapses were there. In case of lapses of technical nature and procedural nature, those offences were required to go before the special courts. Those offences were required to go before the NCLT. Therefore, that offences of the certain lapse of the technical and procedural nature, those were taken out, and those were provided in the in-house mechanism. So it will basically, with a view to provide ease of doing business and better corporate compliance. And apart from this will also reduce the prosecution before the special courts, and also provide this expedient disposal and take up the serious matter by the special court and NCLT. Therefore, these recommendations were made, and the major recommendation, I would like to refer only the major recommendation regarding some of the 16 offences were recategorized, and those were taken as a civil defaults, and those were taken out from the special courts. And with respect to the transfer of the routine matter, normally every matter required to be go before the NCLT, small matters, so even for the change of year, financial year and like that, so those matters have been taken out of the NCLT, and in-house procedure have been provided for that. And the small matter like application for change of financial year and conversion from public to private companies, so these matters are not required to be dealt with by the NCLT with that view. So these matters were also be taken out. And apart from this, two provisions, section 10A and 12, were also introduced. And section 10A provides that in case the non-maintenance of registered office, then the provision have been provided that that company can be struck off. And apart from this, in case of non-reporting of the commencement of the business, they have to require to declare that, and the share is required to be paid up by all the members. And in case they fail to do it, then the provision for a striking off is also provided. So these are, apart from this, some stringent provision have also been provided for creation and modification of the charges. And in case of breach of directorship, because under section 165 the number of directors have been provided, and in case of breach, then under section 164(1), certain provisions are there that the company can also be struck off. And apart from this, ma'am, to enlarge the jurisdiction of the regional director, because for the small matters we were required to, the company is required to go before the NCLT. So the jurisdiction of this regional director was enhanced from 20 lakhs to 50 lakhs. Therefore, the small matters are not required to go there, and by in-house procedure, those matters can be dealt with by them. So at that time, the Parliament, these were the amendments which were of the urgent nature, and Parliament was not in session. Therefore, the ordinance was there. Now, with this, sir, Madam, I request the honourable members to kindly consider and pass this bill.
Yes, Tathagat Satpathy ji.
Madam, last 4.5 years, this House has been mostly considering either laws relating to companies, business or Aadhaar. Apart from these two issues, we have not actually seen much concern of this government, or even prior to this period, when this party that sits to our right, when they were in power, when the Congress was in power, the focus, I have named them, if you can't hear, that is your fault. When they were ruling and when these people are ruling, the concern obviously shows that we are focusing mostly on the haves of this country, on the rich, on people who are doing business of 20 lakhs, which is being jacked up to 50 lakhs, and so on and so forth. I wish to state here, madam, that this is, if you would have heard the Honorable Minister speak also, this is a very hurriedly brought bill just to justify what the government did in the interim period when the House was not sitting. If you see the intention behind this bill and the ordinance that was enacted, it is very clear that there was some one or two particular instances that troubled this government that they wanted to solve. What I would like to know from the government through you, madam, is, isn't it time for the people of India to know that what is it that prompts a government, any government, I am not talking of any particular party, whether it is BJP-led NDA or whether it is Congress-led UPA, what is it that prompts, which are the business interests that prompt them to bring forth ordinances which are out of the normal process of law creation in this country? When we have an active parliament, when we have known periods when Lok Sabha will sit, when the government knows it is in a majority, what is the big hurry to bring ordinances? Therefore, as a general public, one is entitled to suspect the very intention of the government in bringing forth such ordinances and then to justify the ordinance bringing forth such acts. Madam, in my constituency, there was one company, Bhushan Steel and Power Limited, which has been bought over by the Tatas. It's a very interesting story. I'll just say this very briefly and I'll wind up, madam, because I don't think anybody else is going to participate. This company was taken over by the Tatas through this NCLT process that the bill also mentions. Now they are enhancing the power, but this was a big company. Yes, admitted that the original Bhushan people who were the entrepreneurs who had started the steel and power plant there in my constituency, Dhenkanal in Orissa, they probably were not well versed with industrial language. They did not know how to manage the powers that be in Delhi, for which, after the Mines and Minerals Act that was enacted by this government, Bhushans were not allotted the steel, the iron ore mines that they had applied for. And therefore the company started making losses. There was a consortium of banks, and the banks suggested that this company should go through the NCLT process. The company went through that process, and lo and behold, who gets it? A company of 56,000+ crores, worth 56,000+ crores, is bought for something like 34,000 crores by the Tatas. And you'll be amazed to know, and I wish to put it on record, you'll be amazed to know that the moment the Tatas got it, immediately 2 iron ore mines were sanctioned to Bhushan once it was owned by the Tatas. So it was a very clear situation where once the people who know how the machinations in Delhi occur and how the system functions in Delhi, they are the ones who gobble up all the smaller companies that are trying to survive. There is a joke which is going around in social media now. The joke says, first it says me, do you want to buy Air India? Then the second person replies, no, I am a common citizen. I do not have the wherewithals to buy Air India. Why should you even ask me? Then the first person, me, says, then never question if the government of Mr. Modi sells Air India to Ambani or Adani. What I am trying to trying to say here, to clarify here, madam, I do not wish to name any names. I do not approve of political parties blaming each other, calling each other chores. If that be the case, I think nobody will come out clean from the closet. Everybody will fall into the same trap. Anybody can accuse anybody else of being a thief. That is not my idea. My idea is that why can we not bring about transparency? When you are thinking, when you are contemplating of an ordinance, then first bring forth to the public domain who is the ordinance meant to benefit, first. Secondly, when you make it a bill, is it because you have made an ordinance already benefited somebody, therefore you are justifying your act? If that be so, is it good for the country? Is it good for the taxpayer? Is it good for the common man, the middle class man, the poor man of this country? These are facts that we need clarifications from the government. NCLT, raising the power from 20 lakhs to 50 lakhs, this is all hogwash. This is all just something that is kept on the windscreen, that you can put a wiper and you can clean out. That is not the issue. The issue is the government, whichever party leads the government, we are not concerned. The government has to come up clean, and the government should tell us what was the great hurry in having this ordinance done, and why is this bill being brought forth, without telling us the reason, without adding the costs that the nation has to suffer because of this ordinance and this bill. This bill, I think, is improper, and the government should not insist for passing this bill. Thank you, ma'am.
Yes, B.B. Patil.
Madam Speaker, let me thank you for having allowed me to present our party stance on the Companies Bill 2019. As we know, this bill follows an ordinance promulgated on November 2nd, 2018. It seeks to change several provisions of Companies Act 2013 relating to penalties and various other aspects. As the House is aware of, Telangana State finally received a High Court yesterday, 1st of January, after our sustained demands. It is our leader KCR's belief that access to justice should be provided to everybody. People of Telangana continue to show their trust in our TRS party government due to such positive actions. Therefore, any attempt to decongest the judicial system in this country is welcomed by our party. As we can see, this idea forms the basis of this amendment bill. The National Company Law Tribunal is severely stressed due to the mounting number of pending cases. They are obliged to resolve cases in 270 days, which further adds to the burden. Increasing number of cases is not allowing them to carry out with their mandates. The government intends to reduce burden by recategorization of 16 compoundable offences as a civil defaults, and the central government may now levy penalties instead for repeated offenders. The penalty incurred in an incriminated these differences move is highly desirable. Therefore, the rationale of reducing the burden of the NCLT is promising, which is now involved with more urgent issue of administrating bankruptcy law and resolving corporate debt. Previously, when a public company is converting itself into a private company, the authority of approve this change rested with the NCLT. Now the government aims to transfer these powers to central government officials. The provision, while reduces the burden on the NCLT, on one hand gives discretionary power to the central government and its officials on the other hand. Misuse of this discretionary power is of grave concern. It is our belief that when discretionary powers to government authorities are increased, penalty for the misuse of such power should be equally increased. We request the government to make amendments to the bill to reflect the positions. The hallmark of a bad piece of legislation is the rampant use of undefined terms. Therefore, Section 12(9) is a clause for debit. When a registrar has reasonable cause to believe a company is not carrying on business at its registered office, the registrar may carry out an inspection and initiate the process for striking the name of company of the register. The provision of reasonable clause remains highly subjective and, as stated earlier, may lead to misuse of this power. We welcome the government's effort to crack down on shell companies, posing a true problem to the financial security of this country. Section 11 of the Act, which was omitted in 2015, has been brought back as a Section 10A. It requires a verification to be filed by the company of its registered office within 30 days of incorporation in terms of Section 12(2) of the Act. If differences of shell companies is the aim, we propose that such verification process be made a regular event rather than a one-off activity. This shall increase the company's accountability to the state. Another provision of Section 10A requires a director to file a declaration within 6 months of the incorporation, stating that every subscriber to be memorandum has paid the value of the shares to be taken by him. Failure file a declaration, the registrar has been empowered to initiate the process for striking the name of company of the register. This is highly welcome, since it clarifies situation where the registrar is empowered to act. Overall, the bill reflects the TRS government's commitment to ease of doing business. Telangana state, with its investor-friendly industrial policy, TS-IPAS, has succeeded in attracting investment worth $20 billion, about 1,35,000 crores, and created a direct employment to 5 lakh and twofold indirect employment. Telangana state has been adjudicated the second best state to invest in India, and it is our leader K. Chandrasekhar Rao's vision that has propelled our state to the forefront of the Indian economy. Therefore, our party supports every move to further strengthen our state economy and also the countries. We have highlighted some of the gaps in the bill and request the government to give due notice to them. Thank you.
Thank you.
Mantri.
Yes, Minister.
Madam, I would like to clarify some of the issue raised by Mr. Satpathy about why ordinance was there. We could bring the bill. But I would like to make it clear that the Companies Act 2013 and thereafter the IBC, Insolvent Bankruptcy Code, was enacted in 2016. So in that code, the creation of the NCLT, National Company Law Tribunal, whereby since the large number of NPAs was there, so every type of matter, even the small matter relating to changing of the name of the company, changing of the financial year, every matter was required to go before the NCLT. So it created huge number of cases and areas with the NCLT, around 40,000 cases. So if we count it, around this more than 50% cases related to cases relating to lapses of the technical nature or of procedural nature. So question is whether those cases are required to go before the special courts, those cases are required to go before the NCLT. So the serious cases of the fraud are not being disposed of promptly. Therefore, it was decided to constitute a committee under the chairmanship of the secretary. Committee was constituted, certain recommendations were given for recategorization of the offences, where those offences which are compoundable, those offences are not required to be dealt with by these special courts, those offences are not required to be those cases are not required to be dealt with by the NCLT. Therefore, with a view to declog. And the urgency is, Madam, because if we go on keep it, then it was the very purpose of enacting the IBC code was frustrating, because the large number of NPAs were there and the timeline was also fixed under the IBC that within the certain period those cases were required to be disposed of. Those cases were not, the court was not in position to dispose of those cases because the large number of pendency of the cases which relate to lapses like this technical nature or procedural nature. Therefore, it was decided to all the compoundable offences are required to be dealt with by the in-house procedure mechanism in the ministry itself, and those cases are not required to be dealt by them. So with that view, to declog this special courts as well as NCLT, so this ordinance was immediately enacted, and it basically, so we will also decide that, no doubt this came into force with effect from the date when it was issued, but we will certainly also take into consideration that those cases pending prior to coming into force of the ordinance. We will also decide how those cases can be withdrawn and those cases can be dealt by the in-house mechanism. So once we do it, then the burden on the NCLT and this special courts will be very, very less, and they shall be in position to decide the cases as per the mandate given under the IBC. The IBC has been passed by the Parliament, and the mandate has been given that within the stipulated period those cases are required to be decided. And apart from this, I would also like to make it clear that large number of companies were registered, and we, under the able leadership and visionary Prime Minister, the प्रधानमंत्री जी ने डिसाइड किया कि ऐसी कंपनीज जो कि बहुत लंबे समय से जो बिजनेस नहीं करती हैं, मनी लॉन्ड्रिंग करती हैं, ड्रग फंडिंग करती हैं, टेरर फंडिंग करती है, इन कंपनीज को, जो सेल कंपनी जिसको हम कह सकते हैं, कुछ कंपनी नॉन कंप्लायंट कंपनीज है, जो रिक्वायरमेंट है लॉ का 248 का, वो रिक्वायरमेंट फुलफिल नहीं करती हैं, टू टेक द एक्शन अगेंस्ट दोज कंपनीज विद द व्यू दैट द सेक्शन 10A, जो नया सेक्शन जो इसमें बिल में जो है सेक्शन 10A लेके आए हैं, तो उसके लिए उन कंपनीज को चेक करने के लिए, अगर उन कंपनीज के अगर वो कमेंसमेंट ऑफ द बिजनेस अपना डिक्लेयर नहीं करती हैं, अगर कमेंसमेंट ऑफ बिजनेस उन्होंने डिक्लेयर नहीं किया तो ये माना जाएगा कि ये बिजनेस करने के लिए कंपनी बनी नहीं है, उसके लिए पेड ऑफ शेयर कैपिटल उनको पे करना पड़ेगा। तो ये सारा देखने के लिए सेक्शन 10A इंट्रोड्यूस किया, ये भी बहुत जरूरी था, जल्दी था, इसलिए इमीडिएटली एक्शन लिया गया। एंड अपार्ट फ्रॉम दिस, सेक्शन 12 वाज आल्सो, न्यू सेक्शन वाज आल्सो एडेड to ensure that they are required to maintain the registered office. So not only the registered office, they are required to maintain it. There must be a physical office should also be there. Earlier क्या होता था, large number of companies जो थी UPA के रिजाइम में, ऐसी फर्जी कंपनियां जो बनी थी, उन कंपनीज को उन्होंने किसी तरह के उन्होंने शह दिया और उन्होंने उनके खिलाफ में किसी तरह का एक्शन नहीं लिया, और मनी लॉन्ड्रिंग का काम करती थी वो कंपनीज, तो उनके खिलाफ में हमने एक्शन लेने के लिए करीब 3,25,000 कंपनीज को हमने स्टॉक अप किया और उनके बैंक अकाउंट सीज किए, और बैंक अकाउंट सीज करने के बाद में उनके प्रॉपर्टीज के लिए, और इस तरह की कंपनी जो ऐसी कुछ कंपनीज ऐसी भी थी जो ड्यूरिंग डीमोनेटाइजेशन, उन्होंने करीब एक कंपनी ऐसी भी थी जिसने 3,700 करोड़ डिपॉजिट कराया और विड्रॉ किया, ऐसी भी कंपनी थी जिन्होंने 2,300 करोड़ रुपए डिपॉजिट किया और विड्रॉ कराया। तो इन करीब 68 कंपनीज के खिलाफ जो है इस तरह की कंपनीज, उनके खिलाफ में एक्शन भी एनफोर्समेंट एजेंसीज के द्वारा, अलग अलग एजेंसीज के द्वारा वो भी इनिशिएट हुआ है। तो इन सारों को देख करके ऑर्डिनेंस जो लाना इसलिए जरूरी था, क्योंकि इनको डीक्लॉग अगर नहीं करते तो और भी केसेस बढ़ जाते, तो उससे जो पर्पज जो होता आईबीसी का, इंसॉल्वेंट बैंकरप्सी कोड का, के जो टाइमलाइन दिए हुए हैं उस टाइमलाइन में नहीं हो पाते, इसलिए ऑर्डिनेंस लाना पड़ा। इन्हीं शब्दों के साथ में मैं रिक्वेस्ट करूंगा कि जो बिल जो है पास किया जावे।
Bhartrihari Mehtab ji has some clarification he wants to. He can.
Of course, in the introduction, the minister did not mention about the shell companies. Of course, while replying to the debate, he has mentioned about the nuisance that the shell companies have created, especially after the demonetization decision of the government. We started hearing in large extent about the menace that the shell companies have created in our country. And at one point of time, madam, you had yourself spoke from the chair that there is no definition of shell companies. Now, when the group of ministers subsequently, and before that the secretary headed committee wanted to target the shell companies. And you have also mentioned that large number of companies were registered, and it was also found that registration is one aspect, actual address was not, they were not existing at the given address, and money was being floated from one company to another, and it was a money laundering business of many intelligent people of shifting the profit from one place to another, and black money also was getting generated. Tell us frankly, with this new amendment that is going to be, or that has already been enforced through the ordinance and after this bill is passed, can you assure this House that such type of money laundering through shell companies is not going to occur? I would like to remember that when 2013 bill was being discussed in Lok Sabha, 2 times the original bill was redrafted and sent to the Finance Committee. And there another issue also came up, which was first of its kind in the world, that to force a specific percentage of their profit, which we call corporate social responsibility, that was enshrined. And what has happened during last 4.5 years, and many amendments were also done during that period. Now, during this government, around 80 recommendations were given by the secretary-headed committee, which was, of course, later on approved by the group of ministers, and subsequently this ordinance was implemented, and now this bill is before us. With those recommendations, 3 basic issues which are for consideration of this House through this bill. And the recommendations were, first, to curb shell companies, second was to declog NCLT, and third was capping independent directors' remuneration. These are the 3 major recommendations, and what I had, there were 80 recommendations, and it has empowered through this bill, Madam, the union government. There are 16 recommendations which empowers the union government, the central government. And in another way, the ROC are going to be strengthened. At that level, number of decisions are going to be taken. Have you, my question is, third question is, have you re-energized the ROCs which are functioning in different states? Are you strengthening their human resources so that they can actually go into the issues that are being raised in those ROCs? And how quickly those decisions can be taken? These are all in-house decision mechanism which is being built in. And another issue which I would like to mention, Madam, in the section 90, the original, the default that was there, person fails to make declaration, that was there. And penal provision, there was no such provision. And the recommendation of the Secretary Committee had said, the committee recommended that the contravention of the provision of section 90 should include prosecution and should not be limited to only penalty or fine. And what you have done?